afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those of you who have joined us early, thank you for waiting patiently. While we wait for the session to begin, we would like to share a short video about our.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Shareholder Disputes in Family-Owned Companies. My name is Joyce, an associate with Marwin Kwan Associates, and I will be your moderator for today's talk. Allow me to briefly introduce our firm and the work that we do. Marwin Kwan Associates is a mid-sized firm founded in 1985 by Dr. Marwin Kwai. Our able team today consists of 34 lawyers and a team of support of 28. Following his retirement from the Court of Appeal bench in 2015, Dato' Ma now serves as a consultant in the firm. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, a dedicated employment industrial relations team, and a department focused on servicing the needs of the individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch in our office since 2013, some of which were also broadcast live, but with MCO, we have moved online in order to continue with our objective of sharing knowledge, continue with raising awareness and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. Now, let me introduce our first speaker, Sebastian Liu. He is our senior associate at Kwai & Associates. His focus of his practice is corporate litigation and company law advisory. Our second speaker today is Aaron Liu. He is an associate in corporate and commercial department and corporate disputes team in our firm. Today's talk will cover the following main points: understanding family-owned companies, common disputes and legal challenges, case studies and court insights, resolving and preventing conflict. Without further ado, I will introduce our first speaker, Sebastian Liu, to start our talk.
Thank you, Joyce, for the introduction. As introduced, my name is Sebastian Liu, and I will be the first speaker for today's session. I will begin today's session by briefly addressing the dynamics between a company and its shareholders. This first part is mainly for contextual clarity. I will then move on to discuss family-owned companies and the legal risk or complications that may arise from such governance structures, which typically relies heavily on informal practices rather than proper legal processes. After that, my colleague Aaron will take you through the common forms of disputes that arise in such family-owned companies supported by real-world cases. So I will begin today's session by briefly explaining what is a company. A company is a legal entity formed by individuals or groups to engage in business or other activities operating under the framework of applicable laws. The key characteristics of a company include separate legal entity, which basically means that a company is regarded in law to be a separate legal person, distinct from its shareholder. It owns its assets and liabilities, and shareholders are not directly responsible for the company's debts or obligations. Now, the second point is incorporated under law, which means that a company is established through incorporation under applicable legislation, such as the Companies Act 2016 in Malaysia, granting it its legal status. And lastly, limited liability, which means that shareholders of a company typically have limited liability, meaning their financial responsibility is restricted to their share capital or investment in the company. So how are shares and ownership characterized? In Malaysia, a company may issue different types of classes of shares. The most common type is ordinary shares, and the second style is preference shares. But for most classes of shares, it falls under the ordinary share category. So under Section 2 of the Companies Act 2016, shares means the issued share capital of a corporation. Shares, sometimes also referred to as equities or stocks, are instruments denoting some form of ownership of the company issuing them. Next, a shareholder can either be an individual or a non-human legal entity, like a company, for example. A shareholder can be a person or a legal entity whose name is entered in the register of members as the holder for the time being of one or more shares in the company. Shareholder is often still considered an owner or part owner of the company. The owner's share is basically represented by the portion of the owner's capital injected into a company. However, under the principles of limited liability, shareholders do not own any of the company's assets directly and are neither directly liable for the company's debts. So basically in law, shareholders' exposures are confined to the extent of their investments and are insulated from corporate debts. The company itself is liable for its debts, save and except for certain limited circumstances where the corporate veil can be lifted. The shares of a company basically only give their holders for the time being some typical rights, normally those to dividends, voting in shareholders' meetings, surpluses to liquidation, and corporate information during annual general meetings. Shareholders do not have a direct say in the management of the company. This is left exclusively to the board of directors of the company. So at most, the shareholders' involvement in the management of the company is the right to vote at a general meeting, to reconstitute the board or to, say, appoint or to remove directors. Next is other key rights that shareholders may possess. This would include, for item 1, the right to surpluses, which basically means that upon liquidation, after the company's secured and unsecured creditors are paid, the shareholders are then entitled to any surplus assets after these debts and liabilities are fully settled. Second would be the right to call general meetings. So this is a statutory right that is afforded to shareholders holding at least 10% of the voting rights. Such shareholders can either requisition or convene an extraordinary general meeting of a company under the Companies Act 2016. And lastly, the right to receive notices and documents. So where shareholders are entitled to receive notices of meetings, agendas, and relevant documents, these are rights that shareholders do possess, and they are entitled to receive such, for example, financial statements prior to the meetings. Now that I have briefly explained and there is hopefully an understanding of the interplay between a company and its shareholders, we will now move on to family-owned companies, which is the main topic of today's talk. So when we refer to a family-owned company, we are often describing a business whose shareholders, directors, and other key decision makers belong to members of the same family. However, legally speaking, there is no such thing in Malaysian company law or common law jurisdictions as a statutory or formal species known as a family company. Therefore, when we actually use the term family company, what we are really referring to is a privately owned company whose shareholders happen to be related and not a separate legal class. Companies are categorized by statute. Therefore, the Companies Act 2016 only recognizes structured categories such as private companies, also known as Sendirian Berhads, public companies, also known as Berhads, or companies limited by guarantee. The term family company is therefore a commercial label, not a legal classification, and basically captures the fact that ownership and management are concentrated within family members. The misconception actually arises because many owned companies or businesses operate more informally, following family values, traditions, or unwritten or mutual understandings, which may give the impression that they belong to a special legal category. But in reality, they are simply private companies whose shareholding happens to be closely held. Again, legally speaking, such companies remain bound by the same set of rules on, say, directors' duties, shareholders' rights, corporate governance, and oversight mechanisms as any other private company in Malaysia, regardless of the familial relationships or ownership. So this brings us to our next slide on understanding family-owned companies in practice. In practice, again, when people refer to a family-owned company, they are merely identifying the ownership structure. The company, as I've discussed, is normally incorporated as a private company, but its shares are owned by family members who so happen to also run the day-to-day operations. Therefore, although the shareholders are family members, the company is still a separate legal entity. The family nature does not dilute statutory duties under the Companies Act 2016. As such, private companies that are family-owned, it is not uncommon for informal decisions to replace formal corporate procedures. Say decisions being made over lunch, for example, or through WhatsApp messages, or based on other long-standing informal processes. So basically, yes, there is an informal procedure behind family-owned companies. But it's also important to highlight that the family nature does not dilute statutory duties under the Companies Act. So directors must still act in good faith in the best interest of the company, and the company is still separate from the individuals who own or run it, regardless of the blood relations. So although ownership may be confined to family members, directors still owe duties to the company, not the family. The directors cannot rely on familial understanding to bypass statutory procedures. So to emphasize, informal conduct does not override statutory or common law obligations. Rather, being a family business which adopts informal practices merely increases the likelihood of governance gaps, which always create vulnerability when a dispute arises. Now for the next slide, we will unpackage further why informal dealings in family-owned companies breeds ambiguity and creates legal risk. The landscape of company law in Malaysia promotes and prescribes for formal, structured governance through written resolutions, clearly documented decisions, defined roles, and transparent processes. Family companies, however, often adopt an informal approach because of shared personal relationships. So this informality is basically against the norms of corporate governance in Malaysia, and it also increases risk because decisions are made casually without proper documentations or compliance. On that note, many family-owned companies operate on verbal agreements, trust-based understandings, unrecorded decisions, and informal management structures. Such arrangements may work well during, of course, peaceful times or good times, but they are not legally enforceable unless recorded or minuted. Therefore, while these are tolerated in practice, they are not usually immediately recognized in law unless documented. So typically when a dispute arises, especially involving, say, oppression, diversion of company assets, exclusion from management, or any allegations of misuse of authority, the absence of documents or records becomes a major problem. As simple as it sounds, in rendering a decision, the courts basically rely heavily on evidence not family memory or oral promises. So without proper minutes or written agreements, even the most genuine understanding becomes extremely difficult to prove or becomes especially contentious, which correspondingly becomes costly. So in short, the law typically cannot enforce a gentleman's agreement or a common understanding unless it is well documented or corroborated, where failing any such documentations would require or perhaps involve extensive extraction of the existence of such arrangements through oral testimony, which becomes extremely time-consuming, costly, and stressful. So this is why disputes in family companies frequently become messy and emotionally charged. The parties expect the courts to recognize family arrangements, but the court is bound by corporate law and not family history. So informal practices that were never formalized would suddenly become liabilities. The failure to follow corporate norms would result in a much higher bar for the aggrieved party to prove. Now, expanding on the previous slide or a discussion in the previous slide, I will discuss why informality creates problems in court and why the court favor documentary evidence and statutory compliance. When dispute arise, this informality becomes a problem because the issue is essentially that informal practices are hard to prove, although they may not necessarily be unlawful. If matters had been properly documented from the start, much of the dispute and costs would have been avoided. Ultimately, informal practices require a high evidential burden, whereas formal processes provides clarity plus enforceability. So when parties come before the court claiming that this is or this was how the family always did things, they are more often than not going to get a slap in the face with some legal reality that the court's evaluation is generally primarily driven by evidence. The court relies on objective and verifiable documents and evidence such as minutes, resolutions, written agreements. Informal conducts, conversations or recollections of what was intended becomes difficult to prove. The courts cannot enforce understandings unless expressly, impliedly, or have been clearly evidenced. The absence of documentation gives the opposing party the opportunity to deny or even to contradict any alleged understanding, although these understandings were in fact informed during good times. Generally, the court has demonstrated some form of resistance to favoring informal methodologies, and this can be seen in several areas of company law. In general, for example, the Companies Act 2016 imposes strict duties on directors, and those duties apply regardless of whether the company is family-run or not. When these duties clash with historical family practices, the law always prevails, and the court tend not to enforce vague expectations, such as some understanding that the eldest son will eventually control the business. So this is unless such intention appears in the Constitution or is properly recorded in agreements. So I think it's quite clear that litigants from family companies often fail not because the understanding never existed, but because it was never really formalized. So another example is why many family company disputes actually escalate into oppression claims under Section 346 of the Companies Act. So family members may have expectations, and family members may expect to rely on trust and personal relationships, but the court still requires some form of proof of any breaches of obligation and not just emotional history. So the gap between the family expectation and the legal requirements then becomes painfully clear, and it only becomes clear when litigation begins. So next, let's talk about informal dealings. Harmless in peace, costly in war. Now, this is actually to conclude my part of this talk. The main message we wish to touch on is basically informal practices may feel efficient and harmless when everyone is getting along, but they have become a burden once a conflict emerges. What could actually have been easily resolved through clear written procedures now becomes an uphill battle of proving unwritten understandings during times of dispute. Basically, in such situations, it is better to mitigate at the start during good times. Time and resources that could have been spent on business growth is now instead being spent dealing with litigation or forensic reconstruction of past decisions, right? So family companies often assume that we are blood, we don't need formalities, but the reality is that the moment a shareholder feels excluded, a director acts unilaterally, or even the finances are alleged to be mishandled or siphoned. With the absence of any proper governance, it then becomes a weapon for the other side. And without written evidence, each side accuses the other of bad faith, and the court is left with contradictory stories rather than objective facts. I think the data is quite clear that this happens more often than not in Malaysia. So basically, the overarching takeaway is that the law treats all companies equally. If family-owned companies wish to avoid disputes and to protect their relationships, they must adopt proper corporate governance. This includes issuing resolutions, holding minuted meetings, formalizing expectations, and maintaining transparency. After all, good governance is not bureaucracy. It is insurance against future conflict. Thank you for listening. I will now pass the screen over to my co-speaker, Aaron, who will provide some real-world case studies for you all.
Now, the next session, I'm going to bring all of you around in the real world on what common disputes or legal challenges most, if not all, family-owned companies always face when in court. And I'm also sharing some case studies with you all in terms of how the family companies, the directors, the shareholders can mitigate around the disputes that faced by the companies. So now, of course, when familial relationship breaks down, disputes often arise in the company. You would have a family member that holds the majority shares in the company and another family member holding minority shares in the company. And the majority would more often than not sidelining the minority in making any decisions for the company. And you would also have certain family members withholding financial and management information, preventing another shareholder or even family members that's expected to be in the management to have this information. And there are some lack of transparency in the conduct of the company, for instances where, like what Sebastian had mentioned earlier, just for the ease of work, make everything easy. We don't document everything, go through everything informally, getting a mutual agreement through lunch talks and anything. That is actually not so much of a lack of transparency unless you actually properly document on whatever you have discussed. And there will be some other dilution or unfair transfer of shares where you have a certain shareholders moving a motion to pass a special resolution to issue new shares to dilute the shares further for all other shareholders, or unfairly transfer any shares to any other parties that's in favor of them. And also a diversion of business or assets to related entities. So diversion of business can be where a shareholder or a director is giving out business to some favoring parties or some other parties that they have been working closely or sharing a close relations with, sometimes among the family, sometimes out of the family. This kind of dispute can always happen when the relationship or the mutual trust amongst a family member no longer be the same as before. So now, common disputes that a family-owned company always face, of course, the first one would be the minority oppression and mismanagement, as what Sebastian has briefly gone through earlier, Section 346 of the Companies Act, where you have a minority shareholder of the company being oppressed by the conducts of the majority shareholders, not disclosing any information to you, withholding all financial information, conveniently excluding you out of any major decisions that should be made collectively by the family members in the board. And then, of course, you would also have a conflict between shareholders and directors, where sometimes you may have shareholders of one faction and directors of another factions where thoughts don't collide with each other, and this often creates different various conflicts on what the company's future should look like, what the company should do in the next 5 to 10 years or so. And then you have the succession and the control issue, where this group of management in the company disagree with this group of people taking control, or there will be a succession issue when the initial generation in the family passes away, steps down or retire from the management. Then the second generation steps in. That will create more issues on it. And then you have share transfers and exit difficulties, where the family relationship has completely broken down. There's no resolution that can mitigate what has happened, and you want to exit the company, but then the other side withholding you, don't want to buy you out, don't want to take over your shares or whatever. These are also the issues that are faced by individual shareholders in a company. And lastly, you have estate and probate overlap, which there's no clear guidance or clear administration of the estate in terms of a family-owned company. Now, of course, in recent years, more estate cases that have shown that the deceased who owns shares in the family company often was subjected to various litigation procedures because of different informal arrangements that have already been made in the family company, and right now the beneficiaries or the next generation, the successor generations, did not agree to how it should be distributed, on and on. So these are also a legal challenge in a company which involve the probate aspects. Now, the first common challenge is in terms of minority oppression. As I have explained briefly earlier, in a company, of course, the shareholders must abide by the majority rule, where the decisions of the majority has to be followed. However, when the majority rule has been abused, Section 346 of the Companies Act affords the minority shareholders the necessary tools to combat such unfair treatment, which it reads that any member of a company may apply to the court for an order on the ground that the affairs of the company are being conducted or are being exercised in a manner that is oppressive to one or more of the members or debentures holders in disregard of his or their interests as members, shareholders, or debentures holders, or some of the act of the company has been done or is threatened, or that some resolution of the members is proposed, has been passed, which unfairly discriminates against or is otherwise prejudicial to one or more of the members of the debenture holders. There are a lot of cases that goes on and on talking about minority oppression, but what I'm sharing with all of you today here in terms of mismanagement and minority oppression is the case of WTK Realties against Catherine Ma and another appeal. This is a Court of Appeal case which was decided in 2024, last year. The background of it is WTK Realty is a flagship company of a family-owned group, the WTK Group, which was founded by Datuk Wong. And when he passed away, the management of this company was transferred to his three sons. We short form call them WKN, WKY, and WKC. And subsequently, WKN passed away, leaving his wife, Catherine Ma, executor of his estate and a major shareholder, 42.65% shares. Major shareholders here is just a single major shareholder holding the single largest component of shares in the company. But at that point of time, Catherine Ma wasn't reaching the simple majority requirement of 51%. So after his death, the Wong family split into two opposing factions with various different lawsuits being filed against each other. Now, this case wasn't the only one case that was being filed. At the point of the deliberation of the court, there were several other vinyl petitions of the companies in the WTK group were being filed and were being heard together as well. There was various mismanagement allegations and also minority oppression allegations that has been alleged by WKN's wife, and she petitioned to wind up WTK under Section 465, which is on just an equitable ground, alleging that there was a breakdown of trust and mutual trust and confidence and a failure in proper corporate governance. Now, in their argument, Catherine Ma argued that the WTK Realty is a family company built on mutual trust and confidence, and the trust between each family branches irretrievably broke down after the death of the husband. And also, the accounts of the company were not tabled or lodged, and no dividends were declared at all material times. And there was a portion of shares held by WKN was disputed by the other shareholders, where the other shareholders have filed injunctions to block the voting rights of WKN's faction and paralyzing decision-making in the company. And Catherine has alleged and prayed that the company be wound up on the grounds of just and equitable due to the collapse in relationship and also proper corporate governance. Now, in their defense, the company has raised the defense to say that the winding up will not end, and the winding up of the company will not end the litigation, as there are other litigation that's currently ongoing in the group of the companies. And the company remains profitable, and there is no necessary, and if the company is being wound up, all the employees in the company will be affected, and the assets all will have to be liquidated, which they are of the view that they shouldn't be wound up. And there is no deadlock in the management, as the chairman holds a casting vote. There was the mutual trust and confidence, as alleged, existed only between the three son children of Datuk Wong, and not their heirs, meaning the successors don't share the same mutual trust as well. And the deceased rights cannot automatically pass to his family without any express provisions. And also the petition to wind up the company was alleged to be motivated by collateral purpose and bad faith. Now, in the High Court, allowed the petition and wound up WTK under just an equitable ground on the following reasons. WTK Realty was a true family company, and the mutual trust and confidence existed and extended to the later generations, which as later generations were appointed into the board of the directors, except WKN's successors. And there was a relationship breakdown which was severe, which can be evidenced by numerous lawsuits being filed between parties. Now, dissatisfied with the decision, WTK Realties filed an appeal to the Court of Appeal. And the Court of Appeal, after hearing parties, affirmed the High Court's decision and dismissed the appeals on the basis that the breakdown of trust and confidence alone is sufficient to dissolve the company. And the just and equitable ground is not only confined to a quasi-partnership arrangement, and profitability and going concern are irrelevant where relationship breakdown has already destroyed the substratum, and there was no proof of bad faith as alleged by the company. Now, another case which is also quite fairly recent, against Liu Qi, also talk about mismanagement and also minority oppression, where the plaintiff was a shareholder of a family-owned company and was a director since 2003 until he was being removed in 2022. The cousin then became the majority shareholder and also effectively controlling the company. At that point of time, the plaintiff was the bank signatory signing checks for the company, however, was excluded by the company from signing any checks. And subsequently, he was removed as a director. His wife's employment pay was stopped and he was later dismissed as an employee. Subsequently, this was an operation action under Section 346 was being filed, claiming exclusion and denial of fair participation in the company. The plaintiff argued that there was a legitimate expectation to participate in management arising from the 19 years of directorship linked to his shareholding and the quasi-partnership nature of the business. His exclusion from management and also the removal as signatory directors and the stop issuance of the salaries have breached the mutual understandings among the family members. And since he was excluded from control, he was of the view that a fair buyout should be ordered to prevent being locked in unfairly for the rest of his life. The defendant argued that the actions were taken lawfully under the Companies Act and the director's removal was proper. And the plaintiff's claim is motivated to force a buyout at a premium value, and the salary arrangement was illegal as she was a ghost employee and she wasn't working in the company at any material time, which you can't argue oppression on in that case. And there was no legal duty for the majority shareholder to offer a buyout, as the decisions were ordinary business affairs and not oppression. Now, the High Court, after hearing parties, allowed the established oppression and granted a buyout order to the plaintiff, where the brief grounds was that a real legitimate expectation existed for plaintiff to remain involved in management based on his long 19 years directorship, the shareholding which tied to the management role and also a quasi-partnership nature on a family basis. The removal from directorship amounted to oppressive conduct constituting unfair and discriminatory exclusion. The breakdown of trust and exclusion without a reasonable exit option which has strengthened the oppression claim. And the High Court directed that the majority shareholder should buy out the plaintiff's shares at fair value assessed by an independent auditor. So for these two cases, the difference are that there are no proper documentation, there are no proper formal agreement arrangement. Everything was based on assumption. And everything was based on assumption when the next generation comes in, then everything would be different because the same trust don't exist anymore. And also it's not built on the same confidence that each other had with each other when the company was first built up. The second issue would be the conflict between shareholders and directors, where you often have the case of misusing company funds for personal or family benefit, related party transactions without transparency, and removal or appointment of directors for power struggle. So these are also a lot common conflict that we can see when a certain family wants to gain control or usurping the power of the other family faction in a company. One of the famous case is this Dato' Unaba against Eagle and Pagoda brand Tek-On Medical Factory Sendirian Berhad, which I believe a lot of people are quite familiar with this brand. It's a family brand and also a family-owned company, which was originally a family sole proprietorship. Now, this case is a little bit different, distinct compared to all other cases where you have a proper succession plan or you have informally set out the arrangement or based on mutual confidence. However, in this case, the shares of the companies were actually held by each family branch as fiduciary trustees for the benefit of the entire family without any proper documentation, meaning that each of the shareholders in the companies were actually the trustees for the own family. Now, there were disputes emerged in the company where Dato' On discovered that the funds from the customers were allegedly diverted into personal accounts of the next generation, and the salaries, the perks, and benefits allegedly favored only one branch of the family, not mutually agreed to all other family members. And there were violence, exclusion of management, removal, and also oppressive majority conduct being done towards the petitioners, where the petitioners feared for being harassed or being violently treated in the company. And among the arguments raised by the petitioner was that it was a family trust, not a commercial share control structure. And there was a misappropriation of funds where the respondents siphoned millions into personal accounts. And of course, there is a lacking of transparency in accounts, minority being excluded from management, and also any information requested, oppressive conduct, salary discrepancy, removal from office, aggressive behavior, threats, and even physical assaults, like what I've mentioned earlier. And similar to all other cases, respondents usually denied fraud and said that all the monies transferred were business related. However, they were unable to show any proper audited accounts to support this defense. And the petitioners were trying to destroy the company via winding up proceedings and claim that the disputes over beneficial ownership of shares meant petitions should not proceed. And the court allowed the petition and held that the company was a true family settlement company, and there were serious irregularities, lack of accountability, secret banking arrangement, and misuse of funds being done by the respondents. So the court also held that there was an oppressive conduct against minority was clear and overwhelming. And the court decided that a receiver and manager should be appointed to preserve the company's property. Now, the next one would be on share transfer and exit difficulties, where while a family-owned company is built on trust, of course, all these kind of things in terms of shares, ownership, and everything would not be properly documented by the shareholders. I believe that majority of the company, they do not even have a proper shareholders agreement or even a proper constitution in place, where they just adopt the company's acts sample constitution as the constitution for the company, where you always see shareholders would often face the following issues, where you don't have a share buyback mechanism, the valuation and the pricing on company shares will always subject to dispute, and there is a deadlock situations in a 50-50 ownership structure. Now, as in this case that I've explained earlier just now, the buyout order was granted. The defendants have not made any offer to purchase the shares despite the plaintiff's repeated attempts to initiate a buyout after being excluded. So the plaintiff has under several occasions said that, oh, since you have removed me from the management, I don't want to be in a company anymore. I want a buyout. But the defendant has never responded to the buyout, trying to shift it away and say that this was a premium value buyout, which shouldn't be happening. And the court held that when a minority shareholder is pushed out of management, the majority must offer a fair exit, failing which oppression is established. So in this case, if the majority does not offer a fair exit to the minority shareholder, and the minority shareholder is being trapped in a company, having the shares, unable to do anything, can't make any decisions, do not know anything what is going on with the company, minority operation is established in this instance. So an exit option in the court's eye is a core remedy when management participation is denied. The next issue and common dispute usually faced is, of course, succession and control. Now, this is a mix between corporate dispute and also probate and administration, where when you have a second generation that comes in, which would cause a conflict in the roles, the position in management, and also encroachment of rights of other shareholders or directors. There will always be an unequal work input, involvement, and sidelining, where an individual is having lesser work or responsibility compared to the other. And then there is an abuse of control and power dependent on the first generation. And lastly, disputes among siblings or even family members across 2 or 3 generations. In the Dato' On's case, serious disputes emerged when the funds from the customers were allegedly diverted into personal accounts of the second respondent's children. I briefly mentioned this just now, and the court held that there are evidence that shows serious irregularities, lack of accountability, secret banking arrangements, and misuse of funds. Now, in this instance, this case it involves a certain probate and estate administration affairs, as well as I have mentioned earlier. Third On was a true family settlement company. All the shareholders, they essentially the trustees for all family branches. So when they are trustees for all family branches, subsequently their children comes into the company, taking control of the finances, the operation, all the monies they have been siphoning out to their personal account. And this creates an issue where this faction does not believe in the other faction anymore, and the loss of mutual trust and confidence happens from here. And lastly, it will be on the estate and probate overlap, where shares forming part of the estate execute and the shareholders friction, and you have disagreements on whether beneficiaries may become the directors in terms of the tenacity of the patriarchal role in the company. In a big family company, estate and probate overlap often happens where, like the earlier succession and control part, where when you have a second generation that comes in, this creates an issue because more family member is being involved in the company and different opinions comes up here and there. And this creates a problem on who should be the director, should we follow the will or should we contest the will? This also creates a friction among the executor and the beneficiaries. The case study for this is a case of Kok Tai and others against Benjamin Lim Kyong Ho and others, and another case is a 2019 case. And I believe a lot of people here would know who Tan Sri Lim Kok Tai is. This involves the Genting Development Sendirian Berhad, which was a minority oppression case originally brought by the late Sri Lee, the late Tan's wife, founder, shareholder, and director of Genting Development. Puan Sri was removed at the AGM of the company despite historically sharing equal management influence with Tan Sri Lim Gotong and later through her attorney. So she has signed a power of attorney to appoint Tai as her attorney to administer and manage the company's affairs. And this business involves a family-owned lands in Gotong Jaya Township, considered a family legacy, which shall not be sold under any circumstances. And shares were later then passed on to the defendant grandson, minority shareholder, which is Benjamin Lim, leading to conflict over governance and development issues. Now, in this case, there was a family shareholders understanding agreement that requires equal participation in management, and the removal of Puan Sri from the board was oppressive and contrary to long-standing family-based consensus. And she also argued that the status quo of management had been historically respected, including majority shareholder previously yielding to a lot of objections. In response, there was no binding understanding or agreement granting long-term managerial rights to Puan Sri, and justified the refusal to re-elect Puan Sri, claiming that she was the lack of the sufficient mental capacity and disputed the authority of the attorney. And the court found out that this is essentially a dispute involving family companies dynamic and not purely commercial. And there will be a real risk of irreparable harm to the estate if control or land was changed before trial, as the land forms the family legacy. Determined damages would not be an adequate remedy, especially as loss of land could not be compensated in monetary terms. And the court allowing the injunction application, restraining the board changes, land disposals, or any appointment of new directors and company secretaries until the disposal of the main suit. However, as far as we are concerned, in 2019, this dispute in the Genting Development founder family have reached a settlement which was undisclosed to the public. And as you can see, it can go both ways, whether you fight for the company, the control of the company to the end, or you reach a mutual consensus with the other faction. So this is one of the examples. Now, the next topic is for today, and the last one is on how to resolve and prevent a conflict if you are currently in a family-owned company. As what we have said earlier, as what Sebastian has mentioned earlier, a family-owned company is not recognized in law, and it's still structured around the Companies Act in the form of either a private limited company or other types of companies. So how to prevent and resolve a conflict in a family company? You always need to keep a proper corporate governance tools, like we have explained or gone through times and time. Keep every oral agreements through a formal written agreement. Shareholders have a shareholders agreement setting out the terms, the rights and interests of each shareholders in the company. No matter you and your brother are like brothers and shareholders of the company. When it comes to company, forget about your brother title, your sibling title. You need to remember that in company, shareholders are only shareholders, and have a clear memorandum and article of associations with clear voting structures among the shareholders, have reserved matters set out that requiring unanimous approval from the shareholders, and clear dividend policies which benefit all parties equally. Have a proper succession and estate planning. Document all your succession planning early, have a will, have a family trust or whatnot, use trust to hold shares, have different arrangement or agreements which mutually agree and consented by each family branch in terms of shares. And like I said, have a will and how the shares and also the management of the company after the death of the director should be set it out clearly. Under other circumstances, you can also have a resolution pathway. You have board mediation within family, appoint an independent director or advisors, come into the family, act as a buffer, intermediary, and also a mediator to prevent any foreseeable conflict. Have a proper exit buyout mechanism with valuation methodology, drag along and tag along rights and in the form of a shareholders agreement. And like we said again and again, practically corporate governance, professionalism, choose your successor with merit over nepotism or birthright, have a transparent management and financial reporting with all family members involving in it, and treat your business decision commercially, not based on relationship. And lastly, to conclude today's talk, family companies are built on trust, formalities, and succeed by governance. Family companies are built on legacy, but a legacy alone cannot sustain a harmony when a family relationship breaks down. Good and proper governance and structure in a family company can minimize the chances of future disputes, and to prevent any relationship breakdown in the family can affect the operation of the company. Proper corporate governance needs to be followed to protect the interests of each family branch, and in the event that there is no proper governance in the company, the breakdown of relationship will lead to the winding up of a family company. Profitability of the company no longer be relevant, and any succession disputes will easily escalate where rights and authority are unclear. When trust fracture, the company fractures as well. And we'll end today's seminar with a saying: a family business built on trust must evolve into a business built on governance. And that's all from me. I'll hand it back to Joyce.
Thank you, Sebastian and Aaron, for the very insightful and practical tips regarding family-owned companies disputes. So now we move on to Q&A session. We have a question from one of the audience. I will direct to Sebastian. The question is, do shareholders have the right to ask questions of directors at AGM without the need of having to write in?
Do shareholders have the right to ask questions without the need to write in? Yes. So shareholders have the right to attend, speak, and ask questions at AGMs, especially on matters involving the business that is proposed to be transacted, of course, and of course the financials that have been circulated. But I think we must also consider that under the 2016 Companies Act, the private companies no longer are required to hold. So in these situations, if you really want the floor to ask questions to the directors, A, you can either write in, basically to query the director directly, or B, if you have about 10% of the overall voting rights, then you can convene the meeting yourself. But for Berhad's public company, should have no issue. If you are attending a AGM of a Berhad, you have the right to speak, you have the right to ask questions. A private company, it depends on whether they hold AGMs or not. If not, then perhaps you have to convene an EGM, meeting of members, or write into the directors directly. Yeah.
Thank you. We have another question. I think Aaron can answer this. Do shareholders have access to audited reports, and are they allowed to view financial records of their companies?
Yes, the short answer is yes. Shareholders have the right to access to the audited reports, and they are allowed to view financial records of the company. And sometimes shareholders can, if let's say shareholders wants to view the report, they can also go to the secretary office to request and pay a fee to view any financial record of the companies that has been filed with and kept as a record with the company secretary.
Thank you, Aaron. I hope Aaron answered the question. I think there's no further questions, so we shall end here. But before we conclude, I would like to make a few announcements. First, please join us again on the 18th of December. The topic is resignations under pressure, avoiding forced resignation, and constructive dismissal claims. Secondly, please fill in our feedback form and tell us what we can do better next time. The link into the form will be posted in the chat. Thirdly, do follow up and like our social media contents. Fourthly, if you would like to speak to one of our lawyers, we offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us today. We hope you have found today's session informative and useful. And thank you, everybody, and our speakers.